Any mention?
May I place, Your Lordship?
Yes.
I beg to mention item number 8, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
Your Lordship, I'm preparing for the respondent. I have no objection, Your Lordship.
So is requested by the non-counsel for the petitioner. This is matter for 2 weeks.
Yes, Your Lordship. Highly obliged, Lordship.
Yes.
May it please Your Lordship. May it please Your Lordship. I beg to mention item number 7, Your Lordship.
Yes.
If the matter could kindly come up after vacation, Your Lordship.
I have no objection, Your Lordship.
So just speak with the learning counsel of the petitioner and not objected to by the learning counsel appearing with the respondent. This is matter after vacation. Yes.
Deeply obliged.
Obliged, Your Lordship.
Please, Lordship. Lordship, I beg to mention hearing item number 9, Lordship. Lordship, in this matter, I need some more time to complete my written gist. Other side is Mr. Ahmed.
Where is he?
He's not there.
Have you informed him?
I have not informed him.
Just wait for him. Let the matter come up.
I didn't see him today.
And this was hard at some land.
Yes.
Let them.
Yes. Yes, Lordship.
Please, Your Lordship. Your Lordship, I'm mentioning petition has been filed just yesterday, Your Lordship. Criminal petition 62. I beg mention it may be put up tomorrow, Your Lordship. Urgency of the matter is the conducting counsel.
When did you file
yesterday, Your Lordship.
It will come automatically. I don't think you do. It comes.
Lordship, but urgency of the matter is there, so I was just mentioning, Your Lordship.
No, it will be listed automatically. If you filed it yesterday, this will come automatically. There is no need to mention, I think. It comes. Yes, it comes.
I'll just tomorrow, Your Lordship. I'll just please mention them also. Obliged.
Please, Lordship. So I beg to make mention item 2, Lordship.
Yes.
So I'm praying for accommodation, Your Lordship.
This is also another never-ending case, isn't it, Your Lordship?
Three times we have finished the hearing.
All the times not before this court.
But today, Lordship, I thought they should have done it today. It's a Constitution Day. 75 years. Some relief they could have got today.
Fix after vacation, Lordship.
What's it?
This is same audio. Same repeat the same audio. The last one, the petition. Yes.
Liberal.
Yes.
I'd like to mention item 10, Malot. This is a quashing petition, Malot, which we have filed. Now, Malot, the similar issue is before division bench, and that matter is slated to be listed after vacation.
Quashing on
Quashing not compromise, Malot. They are staying as husband and wife. So, Malot, that matter is already sub judice before the division bench. Malot, this matter may also be fixed after vacation, Malot. We'll see the outcome of that.
no objection. This is matter for yes.
Submit causeless. Item number 1.
Yes.
Senior counsel.
Oh yes. Yes.
Your Lordship. This is a quashing application, and by this I am seeking quashing of a first information report dated 24th of October 2024, on the basis of which Rinja PS case number 19 (10) of 2024 under section 75(2) and 76 of BNS 2023 registered. There is sexual harassment, minor and assault. 75. I'll take your Lordship through all this. I just want to, minor, place before your Lordship the background.
Please proceed. Yes.
The petitioner is head of the department of gynecologist and obstetrics department in Northeastern Indira Gandhi Regional Institute of Health and Medical Sciences, nicknames it is shortly called. Now, on 23rd of October 2024, when the petitioner was about to leave, my lord, his OPD office, because he had a virtual meeting along with the director and the secretary to the Government of India, Ministry of Health and Family Welfare. At that point of time, the respondent number 2, who is the informant in this case, she entered his room and she was very agitated. On inquiry, my lord, when he inquired, she told that she had undergone some tests and the test reports were given to her by 22nd of October 2024. And today being 23rd, she has come to show her report and also get herself examined by the doctor. But the doctor is refusing, Dr. Ananya Das, she refused, saying that this is not your OPD. Scheduled OPD, because OPD for her was fixed on Thursday and Friday. If you lordship, annexure 1 at page 16, I'll just show the date and I'll proceed to give the background. This will have some bearing on the case.
Yes.
Your lordship will see on the top, it's written by hand, Thursday and Friday. Your lordship get.
Page 16.
Page 16, my lord, annexure 1.
Yes, yes.
Thursday and Friday.
Yes.
So this was her OPD date, but she came on Wednesday and she was not being examined by the doctor, and the doctor did not even see the report. So she was very agitated. Now the petitioner, my lord, as head of the department, she was sent to him. He calmed her down, and there is always a lady present, my lord, his personal assistant. She is Kong Anita. In his presence, my lord, he calmed her down and inquired everything. He has gone through his report, and then with her consent, he examined her. And examination was necessary to see whether there was any milky secretion from her breast. But on examination, my lord, the petitioner found that there is no milky secretion, and the earlier medicine prescribed to her by the earlier doctor who saw her on 11th of October was perfect, was right medicine. So he asked, my lord, her to wait for withdrawal of excessive bleeding. And then, my lord, out of his concern, he gave his personal number and he said, whenever you come to the hospital, you give me a ring. And this was, my lord, to avoid this situation. When she is not seen by the doctor, she creates commotion. So to avoid that, he has given his personal number and asked, in case of emergency, you can contact her whenever you come to the hospital. Now, later on, my lord, the petitioner came to know that the respondent number 2 has filed a first information report against him under section 75(2) and section 76 of BNS 2023, which was registered by Rinja police station. Now, I am before your lordship, my lord, for quashing of the FIR, and the only one ground is there, my lord. There will be supporting.
When the FIR was lost? When the FIR was lost? What was the date of lodging of it?
It was on 24, and your lordship will, I'll take your lordship through the FIR. If your lordship can kindly bear with me for 2 minutes, I'll take your lordship through. My lord, the ground on which I'm seeking quashing of the first information report is that the allegation made in the first information report, even if these allegations are taken on the face value and accepted in its entirety, then also it do not make out any offence against the petitioner. Therefore, my lord, it's an abuse of process of law if the proceeding is allowed to continue. Now, I'll seek your lordship's permission, my lord, before I place the FIR, which consists of about 13 lines, my lord, and the allegations consist of 6 lines. Therefore, if I can take your lordships through section 75 and 76 and tell your lordship that these are the ingredients, then one look at the FIR and your lordship will see whether the ingredients are there or not. Therefore, before I take your lordships with the first information report, I'll place, my lord, section 75(2) of the BNS. If, my lord, we are having the same copy, your lordship will find at page 73. 73, section 75.
I'm holding wrong book. Wrong book.
Madam, it is Bharatiya Nyaya Sanhita. I'm from Hindi belt, but I find it very difficult to pronounce now. I've been in these areas for the last 49 years. It was inserted in IPC, my lord, in the year 2013 as 354A and B. But your lordship will see from the BNS 2023. I think, my lord, if we have the same book, it is at page 73.
Yes, just a minute.
My lord, my lord.
Yes. No, I don't think.
Section 75.
It's a different page probably in this.
My lord, maybe then we are not having the same book.
Yes. Here it's
75
page 36, 37. Anyway.
All right. My lord, I'll place first 75.2.
Yes.
75.2. Any man who commits the offense specified in clause 1, Roman 1, 2, or 3 of subsection 1 shall be punished with rigorous imprisonment for a term which may extend to 3 years, or fine, or with both. So this provision 75.2 is, my lord, for punishing a person who has committed an offense under 75.1, clause 1, 2, and 3 Roman. Now I will take your lordships to 75. There are 4 Roman sections, but we are concerned with 1, 2, and 3. 75, I'm placing sexual harassment. A man committing any of the following acts. 1. Physical contact and advance involving unwelcome and explicit sexual overture, or a demand or request for sexual favor, or showing pornography against the will of a woman. So if any person commits any of the 3 offenses and listed in clause 1, 2, and 3, then, my lord, he will be punished for sexual harassment, and the punishment is given under subsection 2 of section 75. Now, my lord, the meaning, the first meaning, I'll take your lordships to, meaning of physical contact and advances involving unwelcome and explicit sexual.
Are we concerned with all those things at the stage of quashing?
Yes, and this is bad because if the FIR are, nothing will be there. Not even Roman 1, not even 2.
Whether these ingredients are there or not is not very important factor at this stage. Because if it discloses any commission of offense, that is good enough. Alteration of charges.
I have 3-4 decisions on the point. One is recent decision in 2024 by my Lord Justice Gawai, A. Mohan case, where it says that when the offense can be said to be made out, when an ingredient is disclosed by the FIR. Because just mention that he has done this is not enough. There must be ingredients present in the first information report. I'll take your lordships with all those decisions, my lord. 2024 Gawai's decision. Now, I'll place, my lord, the meaning. You kindly bear with me, my lord, because this is my case. Because at this stage, I'm seeking a stay of the first information report. If your lordship will see Oxford Dictionary, my learned friend Mr. Nongpui will place before you, my lord, the concise Oxford English Dictionary. I'll first show the meaning of explicit. explicit, my lord.
Flag 7, my lord.
The next page you have to see explicit.
Yes.
Explicit, the meanings are: one, stated clearly and precisely. We all know, my lord, things should be explicit, not implicit. Describing or representing sexual activity in a direct or detailed way. So that is the meaning of explicit. Now, overture. Next page, if my lord will kindly see.
Yes.
The last one. Overture, we are concerned with serial number 3. An approach made with the aim of opening negotiations or establishing a relationship. Now, the meaning of this sexual overture, at one place, I got only in the Google, my lord. My learned friend will give your lordship the copy of the Google, where a meaning of the sexual overture is given. But overture is a kind of advance, man, for the purpose of
What is stated in
establishing
the
a
FIR? What is stated in the FIR?
I will show, my lord. Let me just, lordship,
If
kindly
you
bear with me.
take us there, then we can appreciate it more, you see. Probably.
Yeah, it is not there. Nothing is there. I'll show your lordship. Your lordship will
At this
kindly
stage, if
see.
you can confine to the FIR, your lordship, it will be better. Just confine to
Type
the
FIR.
That is exactly.
Type FIR is at page 33.
33.
33 is the type FIR.
Yes.
This is respected sir, I'll start from here.
Yes.
I, Bala, thank you. With reference to the subject cited above, would plead you to lodge an FIR against the HOD, Dr. Santanu Singh, gynecologist, Department Nigrims, Hospital, Shillong, that without any female attendant, he examined me in spite of the fact that I just came to show a report without looking and briefing on my report, which is an ultrasound report and blood report. He literally asked me to lie down for the examination, whereby without using any hand gloves, he initiated to roll up my clothes and asked me to loosen them up, in which he laid his hand in an uncomfortable way on my private parts. After that, he did not prescribe me any medicine. Instead, he shared his personal contact number with me and asked me to meet him anytime, at any day, whenever I visited the hospital and left the room in hurry. This is the FIR. Now, your lordship will see, if I can divide the FIR, I can divide the FIR into 3 parts. The first part says, without any female attendant, the accused examined the patient in spite of the fact that I just came to show my report. Did she object? It is not there. That she could have said that, look, I have come just to show my report. I am not interested in getting myself examined by you or any male person. There is nothing. The second part of the FIR will be, without looking at my report and briefing on my report, he literally asked me to lie down for examination. Well, there is nothing to show that you objected and you said, no, I don't want to get myself examined. I don't want to lie down. She didn't say that. Then the third part, in the last part, without using hand gloves, he initiated to roll up the clothes and asked me to loosen them, in which he laid his hand in an uncomfortable way on my private parts. Now, who loosened it? She doesn't say that. She refused to loosen her clothes, upper clothes, and he did it forcibly.
We are not supposed to see all those things at this stage, Mr.
Why not? Now,
this all will be disclosed at the stage of, see, investigation, maybe or at the stage of trial. Probably you do not have to go that far at this stage. Only thing is, you just tell us that whatever has been stated in the FIR, if it is accepted in total, whether it will make out a case or not, whether that will make out a criminal case or not. Not necessarily under 75(2).
My lord, if the ingredients are not there, there's no question. I'll just place my
No,
lord
but
one
then
decision.
it doesn't mean, you see, if a case is registered under 75(2) and 76, it doesn't mean that
Yes.
charge sheet also will come under that. That can be
No,
investigation will reveal.
charge sheet,
What we are
even
more
if my lord
concerned
suppose-
at this stage is whether any disclosure of offence is there in the FIR or not. That is what.
Yes, that's right. Your lordship will kindly, I'll just place one decision for your perusal. A.M. Mohan versus State, represented by SHO. This is the Supreme Court decision, my lord, of 2024.
Yes.
And the judgment is by Justice B.R. Gogoi, my lord, 3 judges bench.
Yes.
Your lordship will kindly see page 11, paragraph 11.
Act number 4.
At its
Act number 4.
paragraph 11.
My lord, we are here to receive the copy, my lord. It has not been given to us.
These are all proposition of law. Is it required? You should be given all the advance copies. This
No,
is
that
not
apart, my lord, he had been mentioning to some other, referring to it, my lord. The factual aspects, my lord.
May I, my lord,
Yes.
proceed with
Yes,
rule,
please. You are
paragraph
referring to?
11.
You are referring to
Paragraph 11. I'm referring to
7.
paragraph 11.
Paragraph 7.
11.
Yes.
My lord, in paragraph 11, one case, Professor R.K. Vidyasastri and others, this has been mentioned and quoted. I'll take your lordship through the relevant portion. Your lordship will kindly turn to 18. This is of Vidyasastri case. This is the judgment was by Justice Chandra. 18, my lord. Next. Section 420 is quoted, my lord. Lordship has seen penal code. 420 of penal code is quoted. Below that, 19, your lordship will see the ingredients to constitute an offence under 420.
Yes, sir. Please be slow. We are not getting it.
I'm sorry, my lord. Paragraph 11 at page 7. Your lordship got.
It's
Page is below.
Dr. Mojiga, where it is? There's no page.
It is from page is below that. Page 7. A.M. Mohan versus State.
Yes, we are holding that only.
My lord, the page number is below. Your lordship will see on the first page, page 1 of 11.
Yes. Okay. Yes.
Similarly, your lordship will go to page 7.
Yes. We are at
Page 7, my lord, paragraph 11.
Yes.
Now, in this paragraph, R.K. Vidyasarthi case is quoted.
Yes.
In court, in case of Professor R.K. Vidyasarthi and others versus Sudha Sitaraman, reported, has called out the ingredients to constitute offence under section 415 and 420 of IPC as under. Now I will take your lordship to the next page. Kindly turn to next page.
Yes.
18.
Yes.
18, section 420 of the penal code is quoted. Lordship got. Paragraph 18 of Vidyasarthi case only.
Yes.
420 is quoted. If your lordship got that, I proceed
Yes.
further.
Yes. Please go ahead. Please.
Kindly come to 19, the next paragraph.
Yes.
The ingredients to constitute an offence under section 420 are as follows.
Yes.
One, I'm placing. Person must commit the offence of cheating under section 415, and person cheated must be dishonestly induced to deliver property to any person or make, alter or destroy valuable security or anything signed or sealed or capable of being converted into valuable security. Cheating and an essential ingredient for an act to constitute an offence under 420. Now kindly come to 20. Paragraph 20 at page 10, the last but one page. This is the conclusion.
Please.
The dishonest inducement is sine qua non to attract the provision of sections 415 and 420 of Indian Penal Code. In our considered view, the same is totally lacking qua the present appellant. In that view of the matter, we find that continuation of the criminal proceeding against the present appellant will be nothing else but amount to abuse of process of law in miscarriage of justice. Therefore, my lord, and this is also a case of first information report. Your lordship will see paragraph 2. Now, if your lordship permit, I will place another case. This is, my lord, Wait Limited and others versus State of Bihar. I've given it to my learned friend will place it before your lordship.
Flexing.
And this is, my lord, a straight case. Paragraph 14, my lord, if your lordship will kindly take. This is also a case of first information report. First information report is mentioned in paragraph 2. 14, I will take your lordships. Careful reading of the complaint. The last page, paragraph 14.
Yes.
Careful reading of the complaint, the gist of which we have extracted above, would show that none of the ingredients of any of the offence complained against the appellant are made out. Even if all the averments contained in the complaints are taken to be true, they do not make out any offence against the appellant. Therefore, we do not know how an FIR was registered and charge sheet was also filed. So, my lord, any first information report must contain ingredients. Now here, the first information report shows that she was examined, she had not raised any objection, and now she files an FIR. There also she does not say that any sexual advances were made towards her. Nothing. Now a gynecologist, my lord, is at severe risk if this kind of things are allowed. And I may tell, my lord, one thing. This present petitioner, my lord, he has been informed that he has been shortlisted for appointment to the post of director in one of the prestigious, my lord, institution. He doesn't know the name of institution. And then there are people against, my lord, him. And they have orchestrated these. And we have stated, and I'll take your lordship through those paragraphs. My lord, kindly come to ground 3 at page D, my lord, at page 11 of my petition. 11 of my petition.
Yes.
D, I'm placing D. For that, the petitioner has been shortlisted for the post of director in a leading medical college institution, and the pendency of the present FIR may affect the petitioner's prospect of appointment to the said post. And as such, the petitioner suspects that someone in negligence is behind the FIR so that the petitioner is not selected for the aforesaid high-profile job. One more important thing, my lord, which will go towards establishing bona fide is Dr. Ananya Das, who refused to examine the informant on 23rd of October in the morning, and that is how she was agitated and she was sent to me. Dr. Das examined her after after I examined and I left. Kindly see, my lord, page 25. And she changed her, even her OPD days. Kindly see at page 25, annexure 5. Annexure 5.
Yes.
Now, your Lordship will see on the top, patient wants to show to Dr. Ananya Das. If she had not refused in the morning, there was no occasion for that informant to come to me. And then your Lordship will see the date 23/10/2024 on the left side. Your Lordship, that top left side, 23/10, it's by hand. 23/10/2024. And see the date, the day is also changed, Monday and Wednesday. And she was examined and kindly see it's written no milky discharge. This is what I found. And no medicine is prescribed. And she said she has just gone to show the report. And it's on the same day. And we have made a statement in paragraph 7.
How long you have been in medical profession?
My Lord, 36 or 30, I'll have few years. And this is the last promotion perhaps I will get. And this is to install that.
At the end of, is there any such allegation against you?
No, we have made a statement.
No such allegation. This is the first time you
No
have
such
said.
allegation.
What is your age? How old are you?
61.
My Lord,
61. Yes, just let us see what state says. Yes, Mr.
Lordship, at this stage, because if your Lordship will come to page 33.
Page 33 is the FIR. Yes.
Your Lordship, I so and so, with reference to the subject cited above, would plead you to lodge an FIR against the HOD so and so Shillong, that without any female attendant, he examined me. So, Lordship, this is a matter of investigation whether the allegation in the FIR, first part of this, whether female attendant is mandatory. So, there is a matter of investigation. He examined me in spite of the fact I just came to show report. Second part, the purpose of visit was only for the purpose of showing the report, not for any other purpose. She is very categorical on that.
But then she doesn't say that the doctor has deceived her to this thing, for these things.
No,
Has ever forced you.
no, Lordship, I'm just reading there. I'm just reading
We
there.
are going the FIR only, whatever is stated.
Lordship, yes.
Now you see, like to make allegation against somebody who is very senior in this line and who is holding a responsible position, at least you need something. It cannot be something like that you come out and say.
Lordship,
See, appreciate one thing. This incident happened on 23rd.
Lordship, yes.
She filed the FIR on the next day.
Next day.
There is nothing in the FIR which says that she has ever lodged any protest when she was in the hospital. There are some hospital authorities. Did she make any complaint? We will do one thing. You obtain instruction. We will stay this FIR.
Lordship, allow me to just come, because she's also been made a party. At least notice has to go to her.
Yes, definitely. Notice you will go to.
She's part
But
of.
then for the time being, what is the punishment prescribed here? But then you do not have a fear to be this thing arrested.
Under 76.
That 41 is there. 41 is there. You will not be. It is below 7 years. You will not be taken into custody.
My Lord, as abundance, we have obtained anticipatory bail, my lords. For that matter, we have stated in the petition.
See, before whatever the non-senior counsel has stated, we are not going to the facts. You see, we can, one thing this court is aware of the thing, is the version which the accused makes here. It does not have much relevance at this stage. Your story of the fact may not have. That is what the apex court says. That is the principle. So, and we are not supposed to go into all those things. Sexual assertion.
Yes, yes.
The only one thing is, what is this? You see, like a man who is in a profession for a very long time. He's holding high post, and at least the FIR doesn't say so that he has played a deceptive role, tried to deceive these things, tried to force that lady, and there is nothing to show that she has ever raised any objection also.
Lordship, that
She goes back and the next day she files FIR. So that is the only
Lordship, allow me
consideration.
just to read. I've just put it two parts. Let me also just complete the FIR part.
Please read.
So the first part is, Lordship, the female attendant part, this matter of investigation. And at the female part, whether female is required or not, is a matter of investigation. So that cannot be decided while prima facie reading of the FIR. That is something which has to be decided on the basis of investigation. Second, she came to show the report. It's a categorical statement. Now, this has got linked with the third part of my argument. What does the FIR discloses? When she came to disclose the report without looking and briefing on my report, he never looked at the report. There's a categorical statement. which is an ultrasound report and blood report. He literally asked me to lie down. This is where the problem comes in. Report, he did not show the report, and instead of looking at the report, he asked her to lie down. The matter doesn't end here. Further examination whereby, without using my hand glove, this is very crucial again. This is a matter of investigation whether, without checking the report, are you supposed to touch a female body with a glove on or off? She's made it very categorically there was no glove in his hand. He initiated to roll my clothes and asked me to loosen them up, in which he laid his hand in an uncomfortable way on my private parts. Prima facie, there is a whole sequence he has disclosed. No female attendant. I came for the examination of the report. Report was not done. Asked me to lie down. Then the clothes were folded, and then in an uncomfortable way, he touched my private part. After that, he didn't prescribe me any medicine. This is very, very crucial in clinching in the affair.
Come to the provisions of law under which this.
No, Lordship, at this, Lordship, at this stage,
link this fact with the
Lordship, we'll just stick to 75.
Come to 75.2. What does 75.2 says?
Sexual
See,
harassment.
Mr. Khan, as if we are going for a final argument.
No,
here.
no,
Not at
no,
all,
no,
at
Lordship.
this
I am just onto the stage. Prima facie, the FIR discloses offence. It's on the face of it. And 75.2, Lordship, 75.
Definitely, sir.
75, Lordship. A man.
75.2 it says.
A man
or request for sexual pleasures.
No, so a man committing any of the following acts: physical contact and advances involving unwelcome and explicit sexual overtures. Physical contact. Lordship, we'll pause for a minute.
We are reading which part?
75.1 subclause.
We are concerned with 75.2, isn't it?
70.
We are concerned with 75.2.
Lordship, we can 75.1 or 2. That could be a matter of alteration of the charge.
Exactly, we understand. This court is aware of this.
Lordship, at this stage, court will not go into that.
That is definitely.
I will restrain myself from going into that
We
part.
cannot.
But Lordship will just kindly see 75.1 subclause 1.
It's all right. We see that is all right. That is all right.
Lordship, the word used is a man committing and following acts of physical contact. No, admittedly, if you just pause for a minute on the physical contact, there was no requirement for any physical contact. It was only for the purpose of report.
So, if any touch, any inappropriate touch made by the gynecologist, like a gynecologist, would become a sexual offence.
That is a matter of investigation. At prima facie, yes.
See, supposing, do you want to say a male gynecologist cannot examine a female?
He can, Lordship. The context has to be there.
So, what are the norms for that?
Lordship, kindly.
Is whether the law says that it has to be done always in presence of a female?
That is what I am submitting, Lordship. Kindly see the context of this FIR. I come for examination of the report. Report is not looked into.
See, Mr. Khan, at this stage we are not going into all those things.
So
we are just.
I am only in, Lordship. I am only into the part that prima facie.
It's all right. We'll pass on. So,
Lordship, my only submission
you
is
obtain instruction. You see, we are not allowing this petition.
I am not in that, Lordship. I am just making a case, Lordship. The prima facie, the ingredients in the FIR clearly discloses unwelcome, professionally highly unprofessional on the part of doctor not examining the report and then touching her physically in her private part. This clear-cut offence under the FIR at this stage. So there is no question. If it was a borderline area, Lordship, yes. Then subject to whether this can be quashed or not, that would be once we get an instruction and once the private party. But at this point, there is no case of staying of FIR as matter.
When can you have your instructions? Oh, there is a
No,
private party. So nobody has to go.
Lordship, I was about to say on the private party.
Yes.
She has to be heard, at least.
Heard, Mr. Solicitor on a senior counsel, assisted by.
Mr. Nongkui.
Yes, all right. It's all right. We will do this. Give. Returnable in 3 weeks. Mr. A. Khan, Lanet PP. Mr. Gurung is there. Appears for the respondent number 1. Stop. Take steps for service of notice upon the respondent number 2 within 2 days. Give. Yes. Say heard the learned counsel's replying for the parties on the interim period. It appears from the materials on record that the petitioner is a senior medical professional and is
It's ground F, page 12. We have given the detail. Ground F, page 12.
what is it? The last one. Having a professional career spanning over more than 36 years. And in his career, he has held many senior positions in different institutions. It is also apparent that his entire professional career has in his entire professional career there is no complaint against him. Stop. In addition to that, it is stated that the petitioner is aged about 61 years and is unlikely to give indulgence in the kind of activities which have been alleged in the FIR. The allegation made in the FIR prima facie doesn't show that the respondent number 2 was misled by the petitioner and was forced to undertake a medical test undertake the medical test conducted by him. Just say, considering the fact that the petitioner is a senior professional and there exists no other complaint against him, it is deemed appropriate to order the no, but Mr. Dr. Majika, but difference it makes if it is, oh sorry, senior counsel is there Because otherwise there is a
Well, I'll tell you, look, the whole purpose is
yes,
to install my promotion,
yes.
and
All
within
right.
this they'll get nothing will happen to them. After that, your lordship may find them dismissed in my case.
Okay, okay. Just one
Consequences
thing.
will follow.
Yes, yes. Just a minute. Yes. Before that, uh, no. Just what is the how the sentence right in view of no. Last sentence. Yes. What is it? No. Before that, just how we entered the last paragraph. Just last line of the last paragraph. You do one thing. You do one thing before we come to the last conclusion part. You somewhere you say it has been alleged by the petitioner. No, it has been. It has been. It is what we said that these things, the FIR part and all. Thereafter, you just say furthermore, the contention has been made by the petitioner in this criminal petition. That where is the paragraph where you stated that you considered some
Ground D, page 11, my lord.
yes ground B
Ground
page
D, page 11. 11.
yes. It's written that the petitioner has been shortlisted for the post of in a little medical college stroke institution. And do you want to say this FIR has been filed with ulterior motive?
Yes, my lord. Absolutely.
And it is evident that the FIR in question has been filed with some ulterior motive. To affect the petitioner prospect of appointment. Just say somewhere it is before these things. Okay. Now come to the last part. Now where do we see? It is deemed. It is deemed appropriate at this stage to stay the further proceedings of the Ranger
Rinjan,
PS case number 191 within packet 10. You just see in the prayer last part at page 14. Okay, under section so and so till the return of verdict. Stop. This matter after 3 weeks. There may be some correction here, there. Yes.
deeply. Grateful, obliged.
Item number 2. Causeless. Item number 1.
May it please your Lordship.
Yes.
Lordship, in this matter, it's a quashing petition, my Lord. I'm appearing for the private respondent, the complainant. Lordship, we are required to file a small objection against the quashing petition.
You are entering for the first time today?
No, this is the second or third time, my Lord.
You want to file an objection?
An objection, my Lord, if Lordship allows us 2 weeks' time, my Lord, to file the objection.
My lord, my English language is not proper, so kindly grant me permission in Hindi language.
My Hindi understanding is not.
Okay. So my lord, 4 week, 4 week.
Yes, how long you will need?
I want 2 weeks. My friend is saying 4 weeks.
Achha, he wants
to enable him to come.
Yes. Mr. S. Jindal, Learned Counsel appearing for the restaurant number 2. Praise for and granted for 4 weeks time for filing an objection.
Much obliged.
Hearing. Item number 3.
Yes. What is it, sir?
These are those alcohol matters, my lord. Alcoholic dependence.
ADS.
Oh, yes. You are supposed to
Shelter appointment policy.
My lord,
explain us as to what is the shelter appointment.
I have received instructions, my lord. Just
Yes. Have you gone through it? Did you get the time to go through your instruction?
I've gone through, my lord. Only that some rules are required, my lord. I've sent for printing, my lord.
That is okay. We are not, you see, like what we are interested to know is that what kind of duties are performed. If you say that somebody is kept in a sheltered appointment,
it says
what it would mean?
But the rules say non-laborious posts, non-laborious duties.
What is laborious and what is non-laborious? How do you categorize it?
That is, of course, subjective, my lord. Laborious.
No, is there any rule or any direction by which you classify that? Laborious and non-laborious.
Laborious is not, as such, it has not been classified, my lord.
Then,
but in my humble submission, the parameters will be because he is a general duty soldier, my lord. He is the soldier who fights on the ground, my lord.
see, the prima facie, this court is of the view that since you have retained him pursuant to the passing of the interim order,
My lord.
you see, it is apparent that the medical condition, whatever you allege, is not correct. Or may not be correct, and it is not that serious that he cannot be retained in the service. It doesn't seem so. So that is why this court is basically interested to know what is that sheltered.
My lord, sheltered appointment only says, my lord, if any personnel is unfit for regular duty, he can be posted in non-laborious employment.
What is that non-laborious, sir?
That is not been defined now.
Even a clerical job can be laborious.
In fact, clerical job is more laborious.
How do you categorize it and what is the basis then? If you say, since you are using the term laborious and non-laborious, and you say that the sheltered appointment, basically you are trying to classify that something is out of the normal category, isn't it? Well, the sheltered appointment. Then there must be a basis for that. Then what is that?
Well, what I would pray, my lord, this is a fact that because of the interim order is continuing for almost 5 years now, since 6 years in fact. My lord, what I would pray, my lord, but the liberty may be given to us, my lord, to re-examine him whether he's found fit
exactly.
or not.
That will be always be there. It has to be there. It doesn't mean that since if his writ petition is allowed, and then he can carry on drinking and that will be a license for him. It cannot be something like that. It should not be. See, if your rule says that there has to be annual,
Medical examination,
medical condition of a person, this has to go. So can we record the concession made by you and then no?
My lord, in view of the given facts, it can be recorded.
It can be. Yes. Both these how many matters are there?
The two matters.
Same fact, same.
More or less identical, my lord.
But then
The date of employment
dates and all will differ.
Dates will be different. My lord.
The liberty which you are seeking
My lord.
is what? To assess their medical condition.
My lord.
The department should have the liberty to assess
Because
the
what the
medical condition of the petitioner
Right.
and to take action. Or maybe you say like depending on the outcome of these things, they should have the liberty to take appropriate action.
or the other option can be, my lord, the matter may be kept pending, my lord. We will examine him once again. My lord.
You are agreeable to that?
Yes, ma'am.
That is okay. Then in such a case, if you are agreeable to that, then that will conclude the matter here. Are you sure you are no more alcoholic now?
My lord, for the that instruction has to have to take instruction on the with regards to the conscience.
Whether he is still alcoholic or not, that you have to take instruction. And
the client,
probably at what time you were basically asked to contact him.
Or alternatively, my lord, my lord, we can dispose of the matter also, giving us that liberty, my lord.
Then we'll just pass a short order saying that since on the basis of so and so has been passed, this court is not going into merits and all, is disposed of. Okay, and then
The improvement order
with the
will
liberty to so and so to you say like to examine the thing. Will it be possible for you to take some more orders? Can you manage? You are alone today, is not there. Okay. Had Mr. R. Jalander counsel for the petitioner and also Dr. Yan Majika along with MS Mark, Landed Council letting to the respondents. Give a paragraph by this petitioner. The petitioner is challenged the order dated 3rd May 2018 by which the petitioner was made to forcefully
discharged on medical grounds.
By which the petitioner was discharged from
Service on medical grounds.
service on medical ground. What is the prayer, Mr. Cha? What page?
My lord, that is
19.
at page.
This is this order dated 3/5/2018.
My lord.
Have you written 3/5/2018? Stop. It appears from the record that at the stage of motion comma, an interim order dated
My lord, interim order dated 31st July 2018. My lord.
just tell me the last line. It appears from the record that at the stage of motion of this matter, comma, and by interim order dated 31/7/2018. Oh no, they do not say that. Say an interim order was passed in favor of the petitioner on the strength of which the petitioner is continuing in his service till today. Stuff. No attempt has been made by the respondent to get the get the said interim order vacated. Stuff. Since the petitioner is continuing in service for more than 6 years on the strength of the interim order, it prima facie appears that the respondents at present does not have any issue with regard to the present medical condition of the petitioner. Shall we say as suggested by you? Can you say?
But instead of saying that,
It's all right. Can you say as agreed to by the parties?
Well,
give a paragraph in the above situation, as agreed to by the learned counsel appearing for the parties. Without referring to the merits and demerits of the claim and assertion of the parties. For the interest of justice, the impugned discharge order dated 3/5/2018 is hereby set aside and quashed. With liberty to the respondents to assess the current medical condition of the petitioner and to take appropriate
action on the basis of that. If he's found fit, he will continue.
Appropriate action. But then if you say action, then it will be license for action and to pass appropriate order.
Well,
in this regard, that will be better, isn't it?
Well,
in accordance with law. You see, this sentence may become too long. You may break it somewhere, give a full stop, and then so that meaning is not altered.
Date is also same.
Same.
The other matter of date of discharge is also same.
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 Other matter also.
Well, the same.
My lord,
everything is same.
My lord, liberty again challenging the same, my lord.
That is obvious.
That's a fresh cause of action.
That is always there. That is always there. So, that then we say with the aforesaid, in the next paragraph, with the aforesaid, this writ petition stands disposed of. Now you do one thing. In this other, what is the other writ petition? This is 221, and then
that is 222.
That other on 220 also. Only the name of the parties are different and same, ditto same, everything is same order. Okay, we'll have so many words. Yes.
Deeply.
Hello.
Item number 5.
Yes. Yes, Mr. Guru.
My lord, my lord will recall, my lord, this matter was heard. However, my lord, there was a query from this honorable court, my lord.
This is a revision application.
My lord.
Seeking quashing of FIR.
No, my lord. This is
visa. This is a challenge to?
My lord, this is criminal revision petition, my lord, against the concurrent findings of the, my lord, the magistrate first class and the session judge, my lord.
Conviction.
My lord.
But that is why it's a revision, isn't it?
My lord.
Yes.
My lord.
Oh, it is that
foreigners, my lord.
Passport
Visa.
matter, Nigerian.
My lord.
Nigerian. Yes.
My lord, so without entering into the details, my lord.
We are stuck on what point? We don't do going to the details means?
My lord, here the FIR was, my lord, registered under section 468 and 471, read with section 14 of the Foreigners Act, my lord. My lord, the fact remains, my lord, as per the, my lord, evidence, my lord. As per the evidence as well as the FIR. FIR, my lord. FIR is at page, my lord, 4, my lord. Here in the FIR it says that, my lord, the Nigerian national, my lord, the convict here, my lord, had reported before the FRO Shillong, my lord, Foreigner Registration Office.
Foreigner Registration,
my lord, had reported voluntarily as per rules, my lord, his arrival in the state of Meghalaya, my lord. And he was on, my lord, employment visa. So he was playing football, my lord, for various clubs in Meghalaya, my lord. Now, when he reported before the FRO, my lord, they found that there were some discrepancies in the extension sought on 2 dates, my lord.
These employment visas are given for how much period? It is how this is. If it is employment, if it is a regular employment,
till the visa, my lord, is valid, my lord.
Employment visa is also like that. If some person is permanently serving here, then this visa will be periodical.
Whether, my lord, also. My lord, that of course.
Or it depends upon the job which you.
Exactly, my lord.
Is it?
Exactly.
It is something like.
So in my case, my lord, I am on a limited visa, my lord, for playing football, professional football, my lord. So the basic allegation against me is that the visa is forged, and that I have used that forged visa in.
You are ready for disposal of this matter,
my lord. Yes, my lord. There is, my lord. I think I don't see, my lord, if there is any extensive hearing to be done, my lord. The fact remains, my lord, I have been acquitted from the mischief of, my lord, section 468 and 471, my lord. Now point remains, my lord.
Forgery with intention of cheating.
My lord, I have been acquitted from that mischief, my lord. Now, lordship will have to see, my lord, whether at the point of time the FIR was lodged, whether my visa was had lapsed or was, my lord, valid. Admittedly, my lord, as per the FIR and also the evidence, my lord, my visa was valid till, my lord, October 2012, my lord. And FIR was lodged in the month of June 2012. Meaning thereby my visa was valid till another 4 months.
So this FIR was in relation to your illegal stay?
No, my lord. Not illegal stay, my lord. That my visa extension was forged. Forged, my lord. So once that forgery is proved, yes, I have overstayed, my lord. If that is not proved, my lord, my visa extension till October 2012 remains.
Come to the allegation against you. Just to, where is the allegation against you?
FIR,
Take
my
the
lord.
charge sheet or FIR, whatever it
FIR is at page 4.
Yes.
Type. My lord got it, my lord. May I read, my lord?
Yes.
It is dated 19th June 2012, my lord. To the officer in charge, Shillong Sadar Police Station, East Khasiel, Shillong. Subject: legal action to be initiated against Mr. Godfrey Albert Decker, a Nigerian national, in connection with a suspect forged visa. Sir, with reference to the subject cited above, I am to inform you that Mr. Godfrey Albert Decker, a Nigerian national, holder of passport number so-and-so, dated 5/2/2009, valid till 4/2/2014, bearing visa extended number so-and-so, dated 18/10/2010, is a registry of this office, wide registration number, dated 06/9/2011, currently playing from Mulki Football, Shillong. The said Nigerian has obtained visa extension in 2 occasions from the office of the Foreigners Regional Registration Officer, FRRO, New Delhi, duly signed by the Assistant FRRO, New Delhi, wide number so and so, dated 15/10/2010 and dated 15/10/2012. On scrutiny of the visa endorsement of the current extension, it is found that there are some contradictory in the said endorsement, like the date of validity of visa and memo number on the visa endorsement. In view of the above confusion, this office has sought a clarification from the office of the FRRO, New Delhi, about the visa endorsement. On 18/6/2012, a fax message received from the FRRO, New Delhi, byte number so and so, dated 15/6/2012, has confirmed that Mr. Godfrey Albert Decker has never registered with his office and no such extension of visa was granted by his office. Moreover, the stamp which is fixed on the visa was also fake. In this connection, you are requested to initiate appropriate legal action against the said person as per law of the land. Submitted for favor of your kind information and necessity. So, my lord, this was registered.
FIR was lodged by the
My lord,
police.
Deputy Superintendent of Police, my lord, PW1, my lord. So, my lord, here my lord, here the allegation upon me is forgery, my lord. Forgery of visa, my lord. And using forged visa intentionally, my lord.
There are two things, you see. The allegation says Mr. Albert Decker has never registered with his office and no such extension of visa was granted in his office.
Yes.
One is that non-grant of instruction. Then second part it says, moreover, the stamp which is affixed on so and so.
Yes. Forgery.
Two things.
Yes. So, my lord, based upon, my lord, the evidence is collected, my lord. Firstly, the FRRO Delhi, my lord. So, this entire case emanated, my lord, is based on the facts report, my lord. Saying that, my lord, this it was never registered, no, and even the seal which marked on the visa, my lord, is not from that particular office, my lord. Now, when this visa, my lord, my passport was sent to the FSL Shillong, my lord, FSL Shillong, to find out whether the seal is genuine or fake, my lord. He has categorically stated that, my lord, the original with which it is supposed to be compared, my lord, was never provided. So, in the absence of that, now, secondly, my lord, the IO was examined. IO categorically stated, my lord, that she never visited the FRO Delhi, nor, my lord, she found it, my lord, important.
What is the evidence?
Kindly, my lord, is May I take a lordship directly to the evidence of the IO, my lord, to find out, my lord, because my lord, the finding of the trial.
Before that, just if you can take us to charge sheet, just where is the charge?
Charge sheet is at page, my lord, 12, my lord. Serial number 16. May I read, my lord?
Yes.
The prosecution story of the case is that on 19/6/2012, received a written complaint from Sri R.S. Molang, Deputy Superintendent of Police, Iskasiels, to the effect that one Mr. Godfrey Albert Decker, a Nigerian national, holder of passport number so-and-so, dated 052-2009, bearing visa extended number so-and-so, dated 18/10/2010, is a registry of his office, complainant, while registration number so-and-so, dated 6/9/2011, currently playing from the office of Football Shillong. The said Nigerian has obtained visa extension in 2 occasions from the office of the FRRO, New Delhi, duly signed, but the assistant FRRO, New Delhi, dated 15/10/2010 and 15/10/2012. On the scrutiny of visa endorsement of the current extension, it is found that there are contradictory in the said endorsement, like date of validity of visa and memo number on the visa endorsement. In view of the above confusion, the office has sought a clarification from the office of FRRO, New Delhi, about the visa endorsement. On 18/6/2012, a fax message received from FRRO, New Delhi, dated 15/6/2012, has confirmed that Mr. Godfrey Albert Decker has never registered with his office and no such extension of visa was granted by his office. Moreover, the stamp which is fixed on the visa was also fake. Hence the case. During the course of investigation, the complainant and the available witnesses have been examined. The alleged accused person has been arrested and interrogated. The fake passport containing false visa has been seized and sent to FSL for expert opinion. In course of further investigation, a prima facie case under section 468, 471 IPC, read with section 114 Foreigners Act, was found well established against the arrested foreigner Sir Godfrey Albert Decker, son of so-and-so, care of Miss Aruna Phanbu of Jinking, Nangthumai Shillong. Care of Miss Aruna Phanbu. She is the wife of the accused here, my lord. Therefore, I pray to send him up to the court to face the trial during the aforesaid sections of law, and below noted witnesses will prove the case during trial, who may kindly be summoned after fixing the date of hearing, my lord. Now, my lord, before leading into the evidence, my lord, if I may just point out, my lord. So, my lord, basically the allegation on me is forgery, my lord. So, even if, my lord, we take a pause here, my lord. Now, as per the record, my lord, from this my lord, charge sheet, my lord, my visa, my lord, even if it is taken to be forged or if it is, my lord, genuine, my lord, is valid till, my lord, October 2012.
But that is admitted position. Is it the admitted position?
No, my lord. At the point when I was arrested, my lord, my visa was till October 2012, my lord. Now, suppose, my lord, my respectful submission would be, my lord, if forgery is proved, my lord, then of course, my lord, yes, I'll be convicted under section 40.
No, just what you are saying about the validity of your visa. Is it the admitted stand of both the parties? Is it? No. It is you are saying, but then they are not. According to them, these are what? Forged extension.
My lord, this is not a straight appeal, my lord. They are not agreed by that. Since I have been acquitted from 468 and 471, my lord.
We are not on that. What this court is asking question is that you said that at the time when this FIR was lost and you were taken into custody, your visa was still in force.
My lord.
The validity was still is
force.
there.
My lord.
Now, is it the prosecution admits that? Whether that is that prosecution also says that yes.
My lord, the story unfolds this way, my lord. So, my lord, they have received fax message saying that
this is with regard to second extension, isn't it?
My lord.
What was your original thing? The part which is not disputed. Undisputed extension was still what date?
My lord, so far my understanding, my lord, my extension on both the my lord extensions, my lord, that cannot be disputed at this juncture, my lord, because I have been, my lord, acquitted from that, my lord. I have been acquitted.
Acquitted from what?
468 and 471.
So then what is then what for you have filed this case then?
Well, I have been convicted of section 14. That is very shocking, my lord.
Section 14 on
is overstaying in India, my lord. Now, if this forgery is not proved, my lord, at that point of time when FIR was lost, my lord, my visa was, my lord, valid.
Forget about that part which is not proved or these things. If you say that FIR, if your forgery is not proved, then the extension recorded in your visa it stands.
It has to be, my lord. Because, my lord, now, my lord, I'll come to that, my lord. Now, what has happened, my lord? During his examination by the IO, my lord, he has categorically stated that he was injured at that point of time, and he took the name of one Celestian who helped him to, after charging some fee, help him to extend this visa. Now, the lower court, trial court below, my lord, found that since the IO did not examine the person named who had helped him to, my lord, extend the visa, my lord, that was not examined. So, therefore, my lord, he is acquitted. Because she categorically stated, my IO, that she did not find it important to.
Then you have been convicted under what? Then what?
14, my lord. It is very
no, on what basis then? If this forgery has not been proved,
my lord,
that means the extension granted is valid, isn't it?
Yes, my lord. Exactly, my lord.
If that be the thing, then you cannot be convicted under section 40.
What, my lord?
Because your stay cannot be illegal.
My lord.
But then both the court below has given a concurrent finding against you.
My lord.
On what ground? Where is the judgment?
There is no ground at all, my lord.
Then where is the judgment then? Which way then? If you say that is thing, then fail to understand. Yes, Mr. Kharmi, there is no conviction under 468 and 471.
Yes, conviction under section 14.
Then whatever is recorded in the visa, that is correct then.
Lordship, I have submitted the original copy of the visa before this honorable court.
Yes.
Lordship, the visa, it was valid up to 17/10/2011, which means that the appellant is permitted to stay in India up to 17/10/2011. So after that date, the visa, it has expired.
Lord, I just read out the.
So this, but
no,
he continued to stay. There was
according
no
to
extension.
you, there is a fake extension, isn't it?
No.
Fake extension.
Yeah.
Now the fake extension was made by committing forgery.
Forgery.
Now, if forgery is not proved, then how can the fake extension be proved?
Forgery, Lordship, because here the forgery, this appellant, Lordship, he never reported before the registration office for extension. It was done by somebody else.
So it means somebody has forged.
Somebody has forged.
So if this allegation of forgery is not established, then how then the charges under section 14 will come then?
Section 14, because Lordship, there was no extension of the visa. It amounts to overstaying in India. So it is in violation of
See, the allegation which you are saying that the allegation of fake extension. Okay.
Fake extension.
What you are saying is according to outcome of forgery. Okay.
Forgery.
Now, if forgery is not proved, then definitely that there is nothing wrong with the extension. Then that extension has to be accepted then.
Lordship, if your Lordship will go to this material exhibit,
Let
Lordship.
us, we will not re-examine this. We are in a revisional jurisdiction. We will examine it when if it is, we find that there is something.
Lordship,
What is the finding of the trial court? Well,
there are two extensions, Lordship. The first extension, it was okay. There was no no
to
illegality.
You, up to 17/10/2011, that is okay.
That's okay. But
But
after
then
that,
thereafter,
there was no extension. It was extended one day before it expired.
we have to.
So the issue is
go
whether
to the judgment of the things court below. Otherwise, how it will be?
no, one issue is also there, Lordship, whether the extension it can be done retrospectively, long after it has expired.
No, where is the extension? What did this extension was done? See, Mr. Harmi,
yes.
What you say, these are all the parts of the judgment. These are all reflected. If we are not, then we are not going to take into consideration any new facts.
No, no, man.
We will not take any new facts to support the conviction. We'll just see whatever has been recorded by the court, whether these are sufficient or not.
That's because this first extension, if your Lordship, can you see this first extension? The date of the first
Where is that?
extension.
Where can you see?
That the material exhibit I have submitted before this court.
No, but then why you are first taking us to material exhibit? Let us come see what is the controversy. Let us first understand. Let us see what is the judgment says. Whether that allegation of fake extension was dependent on the allegation of forgery or not. If forgery is not proved, then how the fake extension will be proved? Is it correct that forgery has not been proved? Or it is something like that?
The judgment of the trial court, Lordship, is at page 71. It starts from page 71, Lordship.
Anyway, let him read it. This is not your thing.
My lord.
Let's sit down.
My lord, relevant portion will be page 68.
No, but then we have to get the facts. You say, like, just why you are. This is the judgment of the trial court.
My lord.
Trial court.
Yes. Magistrate first class.
My lord.
Yes.
Yes, and what is the finding of the magistrate
My lord,
first class?
page 73, my lord. Page 72, my lord. Page 72, if I may read, my lord.
Yes, yes, please.
Issue number 2 and 3 are clubbed together and discussed for convenience.
Page 72.
72, my lord.
Which part you are reading?
My lord, from the beginning itself, my lord.
No, page 72 starts with the prosecution case in brief.
My lord, page 77.
Page 77, that means. Page 71 is the beginning of the judgment.
Page 77, my lord. May I read, my lord?
Yes.
Issue number 2 and 3 are clubbed together. First thing, my lord, the issues, my lord.
It's a short judgment, isn't it?
My lord. This court perused section 468 IPC, which lays down as follows. Section 468 IPC, forgery for the purpose of cheating. Whoever commits forgery, intending that the document or electronic record forged shall be used for the purpose of cheating, shall be punished with imprisonment of either description of the term, which may extend to 7 years, and shall also be liable for fine. 19. This court perused section 471 IPC, which lays down as follows. Using as genuine a forged document or electronic record. Whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be forged document or electronic record shall be punished in the same manner as if he had forged such document or electronic record. 20. On examination of the evidence, this court found that PW6 in his evidence deposed that PW6 did not make effort to trace the name of the person called Celestian, as accused did not mention that the Celestian is from Shillong, and neither gave the address of Celestian. PW6 deposed that Mr. Celestian may also be accused person as he was named by the accused in his statement before PW6, but accused person is also equally involved in the case, as he must be knowing that such person is involved in making fake visa. 21. From the evidence, it reflects that the material exhibit 1, which is the passport of the accused person, is genuine. However, visa page number 5 of the passport is found to be fake. The evidence adduced by prosecution shows that the accused person left Shillong for Guwahati on 12/9/2011. The evidence shows that when the accused person was asked to report in the FRO Shillong, where he appeared and his statement was recorded, the evidence of PW6 shows that the accused person mentioned the name of the person who helped him with the visa extension. However, the prosecution failed to examine the person who assisted the accused person in obtaining this visa. The prosecution, through the FSL report Exhibit 5, proved that the visa is fake. However, the prosecution failed to adduce evidence to prove that the accused person forged the visa or had knowledge that the visa is not genuine but fake. Issue number 2 and 3 are decided in negative and in favor of the accused person.
What is the basis of your conviction then?
In the light of the above adduced by the prosecution, the prosecution has proved beyond reasonable doubt under section 14. So, my
where
lord,
is that finding? You have not read out that finding. That is the
my
main
lord,
finding.
I'll come to that, my lord. It is at 75, my lord.
So that is the main thing which you have read out.
Yes.
Let us see on what basis you have been.
Page 75.
Yes. Page 75, which paragraph?
My lord, 11. This court pursues section 2A of the Foreigners Act 1946, defines foreigners as follows. Clause A, section 2, foreigners means a person who is not a citizen of India. This court pursues section 14 of Foreigners Act 1946, which read as follows. Section 40, penalty for contravention of provision of the Act, etc. Whoever, number A, remains in any area in India for a period exceeding the period for which the visa.
Is it necessary to you have to go through these provisions?
My lord, no.
Is it necessary to read
No.
this provision?
No, my lord.
Come to the part which would be relevant.
14, my lord. On examination of the evidence put forward by the prosecution, it is found that Office of the Assistant FRRO Delhi extended the visa of the accused person, Sri Godfrey Albert Decker, white memo number so and so, dated 15/10/2012. On perusal of the visa in Material Exhibit 1, it is found that the validity expires on the 16/10/2012, one day after it is issued. The evidence shows that this raised doubt, and on verification with the Office of the Assistant FFRO Shillong, who issued fax message marked as Exhibit 1, it appears that the said visa was not issued to the accused person. From the evidence of PW1, it shows that on 12/9/2011, the accused person left for Guwahati, then reported back to FRRO on April 2012. On the examination of the material Exhibit 1 at page 9, it reflects that the visa was issued on 15/10/2012 and the accused person was permitted to stay in India on or before 16/10/2012. But this court examination, on examination of Exhibit 3, the seizure list dated 19/6/2012 bearing so and so found that the passport bearing so and so was seized from the possession of the accused person on so and so on 19/6/2012. On examination of the date of issuance of the visa, the date when the passport was seized in this case, this court cannot ignore the discrepancies. The passport was seized on 16/9/2012, but the visa was extended on 15/10/2012, which raised doubt as to the genuineness of the visa. On further information of the
extension was given at the time when the passport was in the possession of the police. Is it?
My lord, that till now so far it points to that.
That is
it
what
points
the
to that, my lord.
The passport was seized on 19/6, but the visa was extended on 15/10.
It points to that till now, my lord. On further examination of the evidence with the FSL report Exhibit 5, it reflects that the visa bearing number so and so, page number 5 of this, was found to be a fake one, and it did not give fluorescence when exposed to ultraviolet light. However, from the evidence of PW5, it shows passport is genuine but the visa is fake.
There's something, some Xerox part is missing here.
Yes, even in mine also is missing.
What is that?
Report, it reflects that visa bearing number so and so on page 5 of the passport.
How to presume that?
It is passport. What was found to be fake one, and it did not give fluorescence when exposed to ultraviolet light. However, from the evidence of PW5, it shows that the passport is genuine but visa is fake. On careful examination of the evidence, this court found that the accused person, Sri Godfrey Albert Decker, is not a citizen of India, and he remained in Indian territory without valid visa.
But then how? This is very cryptic. I
Exactly,
not
my lord.
understood this.
Once I have been acquitted after taking all the evidence, my lord, then how can I be
Who is
held?
PW5?
PW5 is the, my lord, the FSL expert.
Now, one thing is very, this court is very much confused is that, let us go by the finding. If the finding of the trial court says, this passport was seized on 19/6/2012, isn't it? And the visa was extended on 15/10/2012. The visa means is the endorsement of the passport, isn't it? It's not a separate. Now, if the passport is in the possession of the police, how visa can be then this thing granted?
My lord,
at least on the same passport, isn't it?
My lord.
Now here it says, in somewhere this court, the trial court has said that the passport is genuine, but then visa is fake. Where is that? You have read out just now.
Yes, just now I read out, my lord. Here, my lord, paragraph, my lord, 16. Last line. However, from the evidence of PW5, it shows that the passport is genuine, but visa is fake.
Now, yes, you do not know since, but then is it not something confusing? Now, the visa is given on the same passport which was seized, isn't it? Which was seized, isn't it?
Yes, yes.
Now, if it is not there in the custody of the police, even after it is seized, that means who will be responsible? The police will have to explain it.
No explanation, my lord.
No. Is it just?
That may not be the case, my lord.
Whether we do not know. Just is it correct that this court is seized? This 19/6 is 2012. The passport was seized.
Yes.
Now after the seizure, it remained with the police.
Yes.
And on 15/10, the visa was granted. Visa was extended on 15/10.
15/10.
That is what this page 76. It is the last line of the paragraph 15.
Yes.
Is it correct? Is it correct or not? This is very confusing. How it can happen?
Exactly, my lord.
Something. Say it's a kind of impossibility. I do not know. Just clarify that part. Whether this court has got it correctly or not. It should not be something like that. You see, like that is something what is not correct. This court gets it. You see, the court should not have any kind of misunderstanding.
My lord.
Now, this last line of paragraph 15 at page 76 says the person was section 19/6/2012 and the visa was section 15/2012, which raises doubt as to the genuineness of the visa. Very correct. But the only question is that if visa is an endorsement, if visa is granted by endorsing of the passport, and the court says passport is genuine, visa is wrong, then how this court failed to understand how if passport which is stood seized by the police,
exactly,
a false entry of visa can be made there.
Yes.
Now how Is there any clarification on this?
No, my lord, nothing. But my lord, my respectful submission would be,
When the FIR was lost against you?
my lord, kindly is 19th June 2012.
19/6/2012.
My lord,
When the seizure was made?
seizure
Same
was
day, same day.
Same date.
It says on 19/6. As per the court's order, isn't it?
My lord.
Now thereafter it remained with the police.
My lord.
You did not take Zimma.
No, no, never.
Now this entry,
Exactly, my lord.
which the court is saying apparently as false, this is made on the same passport.
My lord.
Then how can it be if the passport is in the possession of the police after it was seized? How this entry, whether genuine or false, be made without their knowledge?
Exactly, my lord. This cannot be settled on me, my lord, because
Mr. Kharmi,
Yes,
just clarify on that point. Otherwise, you see, like this court is hugely confused on that part. It means the date on which the court is saying the fake visa entry was made on 15/10. The passport was in your possession.
Yes.
So how could a fake entry be made in that passport?
This finding, Lordship, is on the basis of the evidence of the PW1.
No, how can it be? Is it possible? Say supposing if he is to be held responsible for fake entry.
Yes, Lordship.
If he is to be made responsible for fake entry and he makes it on the passport which is apparently in your possession, how can it be done? How can it be affected? You please clarify on that. We have not understood that. And that is what this is and that on that basis the court is convicted.
Yes, I have understood, Lordship. The seizure it was on the 19/6/2012.
Yes.
But that extension it was after this.
Yes.
On the 15/10.
The extension is made where? Extension is made where? On the same passport or not?
Yes, it is made on the
If it is what seized by you and it was in your possession, how that extension be made in that?
Yes, I've got that point, Lordship.
So
Seizure was on 19/6/2012.
How do you clarify that?
Extension was on 15/10 after the seizure. That point I have understood, Lordship. Seizure, if I may take Lordship to seizure list.
You do not have to show it so long we do not dispute this. It seems we are not in dispute with this thing. You do not have anything with the procedure. Record seizure 19/6. We go by 19/6. You are also not disputing. So after 19/6, this passport was with you.
Yes.
It was seized, isn't it?
I understand.
Now thereafter, if any genuine entry or even a false entry is made, how that would be made by him?
When it's in the possession, it's
You explain that how it is
within the custody of the investigation.
Yes, how you will?
I got that point.
Yes, please clarify it.
I'll just clarify it.
Please clarify. Can you now?
19/6.
Now, what surprises this court more is that the court says, trial court found that passport is to be genuine and entry to be fake. Now, during the custody of the passport in the possession, if any fake entry is made, they are responsible, you are not responsible.
Exactly.
Lordship, the previous extension, it expired on 17/10/2011.
Yes. No dispute to it.
So he was.
We are only expecting that answer, Mr. Kharmi.
10,000.
I do not know which way you are trying to explain it. Just tell us if that passport is seized and it is with you. If any false entry granting visa is made on your passport.
First one was genuine, which was still 2000.
Yeah, that one is.
The second one, which is in dispute, is given with a fake seal.
And that becomes the ground for this thing.
Yes. The first one, it is. There is no. There is no.
About this, Mr. Guru,
there is
very
no
surprising.
problem.
What the finding of the appellate court with regard?
My lord, nothing new, my lord.
Nothing
Simply, my lord.
Endorse the view expressed. Just tell us how it is possible, Mr. Kharmi.
One document is there, Lordship, one letter.
You cannot convict somebody on the basis of some imaginative entry made.
Yes, one letter is there, Lordship. It's 17 April 2012. But that letter is not here in the paper book, Lordship.
Forget it, this letter. You just tell us that if you are admitting that this after the seizure, What is the passport? What is the passport? You have that passport?
Yes, yes, Lordship. I have submitted before your Lordship.
Is it there?
It is there, Lordship.
Just pass. This endorsement is on these things. The endorsement which that said to
My
be
lord,
false
is in the passport.
it is in the passport.
My lord.
Now, if it is in their custody, how that can be made on this?
Exactly, my
And
lord.
that is also during the time when it was in their custody. That is what they will have to explain. And very surprisingly, the trial court has taken knowledge of that, and then it records. However, the evidence shows that passport is genuine, but the visa is fake. Now, it seems the trial court has accepted. Now, passport remained genuine, the genuine one which they have seized. Now, if fake entry comes, who will exploit it? It is for him or for him?
Definitely,
No,
it was in their custody, my lord.
This is what you have seized, isn't it?
Yes, Lordship. Yes, that is the.
That remained in your custody. You have seized it on 19.6. And entry came on 10. Then you have to explain.
Yes.
What is the entry?
Page 5, my lord.
19th.
And page 9. Page 9, my lord.
Very surprising. Yes.
Visa is there. The first extension is there.
It is made. And which number you also dated? Now, who made this entry?
These entry, Lordship, are made by the registration office. The seal, the.
But then it was in your custody.
That's what, Lordship. I'll just try to.
It is explicit 15/10/2010. No, here it is 2012. Now that is very surprising. Again, Caesar is no. 15/10/2012. Yes.
The second extension, Lordship, permitted to.
This is marked as C. Exhibit C.
Exhibit C.
Now here it is specifically shown that this entry was made on 15/10/2012.
15/10/2012.
Now, admittedly, at that time,
permitted to stay till 16/10/2012.
Where is the Caesar list?
Seychelles is page 18.
Page 18.
Page 18.
Now, it will bring more trouble then. We'll pass order directing inquiry against those police.
Page 18, Lordship.
This cannot be something like that. If it is something.
The Seychelles page 18. I, WPSI so and so, do hereby today 19/6/2012 seize the below noted document from the possession of Godfrey Albert Decker, son of so and so, under street of Shri Thatter, son of so, street of Nigeria. In connection with the above noted case, the seizure has been made in presence of the undersigned witnesses. Description: one passport bearing numbered in the name of.
Now tell us how this entry has come during the time of this thing. No matter when it remained with you. Page 19 is this things, typed copy. Okay. There is no doubt that it is 19/6/2012. It doesn't appear to be any clerical error here. No overriding, nothing. Now we'll have to explain that.
Seizure, description of seizure is passport. One passport bearing number so and so, issued by Republic of Nigeria. And number 2, Xerox copy of residential permit issued by Iska Sales.
No, what we have to do with all those things?
The visa is not mentioned.
Just let us remain confined to the issue right now.
Yes.
That question. Have you seen this? You want to see it again?
Lordship,
you have a copy with you.
I have this Xerox copy with me.
Okay. So you have seen the entry here. It is 15/10/2012.
The second extension, 15/10/2012.
That is in dispute. Second extension is in dispute. First is not in dispute.
Not in dispute.
Now, if this 15/10/2012 is in dispute, this entry has been made when this passport was with you. How it has caused that? How it could be done? Just tell us.
Lordship, I think I'll have to go to the evidence of this PW1, who is the complainant.
Yes, please you go through and give a suitable explanation. We'll have it next week. We are not leaving it.
Yes. Next week.
And then it seems trial court has such a glaring point, Mr. Gurum. We do not know. Why?
My lord, in the meantime, my lord, I may be given a copy of this. My last one was not legible, my lord.
The fax message
There
clarification.
is nothing to see, Mr. Guru. You can see it and return it. You do not have to copy of this. Just see, this is the entry which is in question. Now, this code had to go to 2-3 times through this because this is something utterly confusing.
Yes, it's very, very clear, my lord.
If any passport remains in their possession, how could the entry be made here? Just how could entry be made there? And by him. He has no this thing, and then see no hand. It is assumed. So somebody must have played hand from your side. If something is in your pocket, I cannot manipulate it, isn't it?
Yes.
Until and unless you allow me. So that is what.
My lord, my respectful submission, my lord. Since last 12 years, my lord, I am in Shillong, my lord. I got married, my lord. I have got 2 grown-up children now, my lord. I want to go back to my country and celebrate the Christmas.
Your family is here. What is the eagerness to go back?
My lord, all my parents, my lord, and siblings are there, my lord. So therefore, my lord, if this matter can be disposed of before Christmas, my lord.
All along, record says that you were asking for time.
I get it, my lord. I get it.
See, let us see what explanation it comes. It appears to be quite serious. That how can a document which is with police, the investigating authority, can be manipulated? And you have to see whether it has been manipulated with the purpose of victimizing the person only. It gives that kind of things. Otherwise, nothing will be done purposelessly, isn't it? Now, there has to be this thing, explanation, basing on the materials on record. You cannot bring any new story which is not a part of record. We have to explain this.
We have noticed that issue on today only, Lordship. All along this issue, we never.
Lordship had pointed out. In fact, I am grateful for that, my lord.
Anyway, we'll
Mr. Guru, what we need to basically see is that we must have a conscious reading.
My lord.
It should not be a mechanical reading.
My lord.
Yes.
That is what. It is not that these things we jointly read. System is made that way so that see, like you do not commit mistake.
My lord.
Now that is quite surprising. A thing which was there before trial court, it came to appellate court, and now it is before High Court.
My lord.
And they are glaring mistakes.
Yeah, that issue I've understood. We'll
that
see.
issue, and that is quite serious issue.
We'll have it next week, my lord.
Next week.
Time is so less, Mr. Gurung. That is what the problem is. 2 weeks. The wintering is approaching, and then we do not want to keep anything reserved for the winter.
Exactly.
No work is done during that time. Anyway, we'll give a try. We'll keep it next week. We'll give a try. Try to find out, Mr. Try to realize the seriousness of the issue.
Yes, Lord.
Of course, if this post has any misunderstanding, clarify it.
Yes, Lord, you will have
should
to.
Not be something like that, that we basically go for a ridiculous. Should not be something like that.
I'll check it and I'll come with a clarification.
My lord, I'm grateful, my lord. Very grateful. My line of argument was once I'm acquitted from 468 and 71.
We understand, and we are examining that part only.
My lord.
And it has been revealed by this.
My lord.
But then you did not take that specific.
Exactly.
Such a vital point. What happens if you are successful in your revision at this stage, what about your stay here? Now you are here, isn't it? On bail.
Right.
Now this stay, will it again become a problem?
No, my lord, in that situation, my lord, the FRO Shillong, my lord, they have got the power to, my lord, give exit visa, my lord.
See, please guide this court. You should not commit
Yes,
any
yes.
illegality.
I have that, my lord.
This court has no expertise
No,
over
no,
those foreigners issue.
my lord. My lord. In fact, my lord, if it is a, my lord, section 14 violation simply seated, my lord, there are provisions to, my lord, give notice to leave the country, my lord, within such and such time, my lord. If it is not, it is violated, then my lord, proceedings started, my lord. I've got number, on that line, I've got number of judgments, my lord.
So the criminality can be fixed, criminal liability can be fixed on you only after fulfillment of those procedures. Issuance of notice and all.
My lord, here in this peculiarity of this case is, my lord, this 14 has been connected with 468 and 471.
And you say there is nothing on the record
My lord.
to show there is any denial by the official concerned to say that this entry has not been made by them.
No, my lord.
Those officials, those are responsible for making this entry, they are not examined.
Not examined.
That communication from Delhi to here,
only facts, my lord.
Only facts, and that has not been proved.
No, my lord.
Mr. Kharmi, it
Facts
seems like
message.
something is fishy about it. This is something very, very unusual. Yes. Let's just say hard the counsel for the parties at some length. As then Dr. Khurshid, you say as requested by Mr. H. Kharmi, learned additional PP. This is matter after a week to enable him to obtain further instruction. Please see, we should not bring any more trouble.
Yes,
Yes.
Lordship, I'll
Deploy.
definitely see it.
Item number 6.
Okay, there are some more items are there. Oh. Yes. Sir, ready for hearing?
Yes, Your Lordship.
Ready for hearing?
Yes, Your Lordship.
You're ready for hearing?
Lordship, as per the last order in this matter, the respondent 8 is supposed to file the affidavit. Your Lordship.
Oh, you have not filed affidavit.
For respondent number 8, my lord, I need some time to prepare my counter affidavit.
He should have made a mention during mentioning hours. We have been kept
No, but
waiting
then
for the whole
asking
day.
for time is something, you see, it cannot be in the mention hours. It has to be at the hearing. He is asking time for running any affidavit, not an adjournment. Yes. Mr. Singh.
Yes.
Mr. Singh, learned counsel, appearing for the respondent number 8. Praised for and granted further?
My lord, for 3 weeks.
3 weeks time for filing in counter affidavit in the matter. Prayer allowed? List of proceedings.
No
Yes.
pledge. No pledge, Your Lordship.
Item number 9.